Senator from Kansas. Madam President, the American people are worried about the direction of our country, and I absolutely share their concern. The public has witnessed Washington's growing disregard for the Constitution and its limits on government power. Too many of those powers see no limits to their authority, and that, to me, is frightening. The size of government has exploded. Spending's out of control. The national debt is soaring, and Congress has passed thousands of pages of legislation with little concern for the effects on the rights of everyday Americans, and with no thought at all for the debt that we saddle our children and our grandchildren with. The Founding Fathers knew the dangers of expanding government power. The Founders knew what Barry Goldwater knew when he said, and I quote, a government strong enough to give you what you want is strong enough to take it away, unquote. They established the judiciary branch in order to protect against an overly aggressive government. They envisioned it as a neutral arbitrator of disputes based on the written law and as a check on government power grabs beyond the intended authority. This is why the judiciary is so important and why the lifetime appointment of a justice to the Supreme Court is one of the most serious actions any of us will consider. We must have judges who are committed to the job of holding us to the words of the Constitution and laws that are written. We in Congress have proven again and again that we won't limit ourselves, and the executive branch continues to do the same. The American people knew this, and that's why they are concerned about President Obama's nomination of Elena Kagan to the U.S. Supreme Court. I'm concerned that Ms. Kagan doesn't seem to recognize the limits the Constitution places on the federal government and does not understand or seem to understand the role of the Supreme Court justice. Ms. Kagan, of course, does not have a judicial record for us to base our decisions on. And I don't think that that alone should disqualify her. But it does make it difficult to discern how she will perform as a judge. Ms. Kagan has spent most of her career in political roles in the academic world. I don't think it's appropriate to cast my vote based only on her politics, but I do think that her record shows that she's been unable to separate her politics from her legal advice, even in her purely legal role in clerking for the Supreme Court. This is incredibly problematic. I'm concerned that Ms. Kagan will only further the rapid expansion of the federal government, that her actions, and particularly on issues such as military recruiting, Second Amendment rights, and abortion, show that her first allegiance is to her own political views. Her record and her testimony demonstrate that she is likely to limit the powers of the federal government only based on her personal political views and not based on the enumerated powers of the Constitution. Our Founding Fathers established a federal government of limited power. They enumerated those powers and intended the list to be exclusive. In the 10th Amendment, they specifically state that powers not expressly granted to the federal government in the Constitution are reserved for the states. Everything not specifically named in the list of congressional powers was intended to be beyond federal government reach. Unfortunately, legal progressives have sought to stretch that list far beyond its breaking point. Often they have chosen as their tool the Commerce Clause, which gives Congress the authority to regulate commerce amongst the states. Over the years, Congress has relied on the Commerce Clause to pass laws well beyond the scope of what our Founding Fathers intended. Laws regulating matters totally unrelated to interstate commerce, such as how much wheat a farmer can grow on his own land for his own use, or where a person might possess a firearm. The framers intended the limited nature of Congress's power as a method to protect the freedom of individual Americans to go about their lives without undue interference from government. But the limits the Constitution established matter only if our judges are willing to enforce them. I'm sad to say that I do not believe Ms. Kagan will enforce those limitations. During her hearing, Senator Coburn asked Ms. Kagan a very basic question, but it's an important question that deserves a direct and straightforward answer. Senator Coburn asked this, and I quote, "If I wanted to sponsor a bill and it said, Americans, you have to eat 3 vegetables and 3 fruits every day, and I got it through Congress, and it's now the law of the land, does that violate the Commerce Clause, excuse me?" While Ms. Kagan acknowledged this would be a dumb law, she repeatedly stated that the court should give great deference to the will of Congress. She said, and I quote, "We can come up with sort of, just ridiculous sounding laws, and the principal protector against bad laws is the political branches themselves." I can certainly see why the American people are afraid if the task of protecting against bad laws is left solely up to the political branch. Ms. Kagan had extreme difficulty in recognizing any limit at all on federal powers. She simply refused to acknowledge that the federal government cannot pass a law telling American citizens what to eat. Of course, I can see why the Obama administration supports her. The recently passed health care legislation is an exercise of unprecedented government power. The new health care law mandates that Americans purchase health insurance. By forcing Americans to purchase government-regulated insurance and by threatening them with IRS tax sanctions, the Obama administration is forcing its way into American lives in a way this country has never witnessed. Never before has the federal government forced Americans under threat to purchase a particular good or service. I strongly disagree, and most Americans disagree, with this expansive view of the federal government's powers. We need justices on the Supreme Court who are ready and willing to stand up and defend the Constitution. We need justices who recognize that there are, in fact, limits to the federal government's powers. Not only must Supreme Court justices recognize and enforce the limitations of the federal government, but they cannot owe any allegiance to advancing the political agendas of the president who appointed them. I do not believe that Ms. Kagan fully appreciates this critical point. To the contrary, I believe that if confirmed, she will be tied more to her own political agenda than to the Constitution of this great country. Ms. Kagan's record is truly disconcerting to me. Throughout her career, her record reveals that she's put politics above the law. Such a philosophy has no place in the Supreme Court. I oppose Ms. Kagan not because of her political views. I oppose her because she's not demonstrated an ability to leave those political views at the courthouse door. As such, she fails to meet the minimum requirements for any judicial appointment: impartial fidelity to the written law. On military recruiting, Ms. Kagan has fought zealously to keep recruiters off our campuses during a time of war. As dean of Harvard Law School, she sent emails to the entire Harvard Law School community saying it abhors her the military's don't ask, don't tell policy, and calling it a profound wrong, a moral injustice of the first order. The Obama administration has defended her actions against military recruiters, saying these claims were overblown because she ultimately continued the practice of her predecessor in allowing the military to recruit through the school's veterans organizations, which was primarily a social organization with fewer than 20 members. Yet even this paltry action was only a way to continue to receive federal funding for the school. A federal law known as the Solomon Amendment denies federal funding to any institution of higher education that has a policy or practice that either prohibits or in effect prevents the military from gaining access to the campuses or access to students on campus for the purpose of military recruiting in a manner that is at least equal in quality and scope to the access to campus and to students that is provided by any other employer. And even then, she explains that doing so caused great distress. Ms. Kagan did everything she could to fight the Solomon Amendment, even signing on to an amicus brief in the Supreme Court in the case of Rumsfeld v. Fair, with about 40 other law professors opposing the amendment. The Supreme Court unanimously rejected their argument. Not one justice found it convincing. Not Soter, not Breyer, not Ginsburg, not Stevens. Ms. Kagan's demonstrated similarly poor judgment on the Second Amendment. When she was clerking for Supreme Court Justice Thurgood Marshall, she had the opportunity to consider Sandridge v. U.S., a D.C. firearms case remarkably similar
Senator,
to the...
you've consumed the time you've asked for.
Madam President, have I consumed 15 minutes?
All of the time that was allotted to the Republican side has expired.
I thank the chair.
Madam President.
Senator from New York.
Thank you, Madam President.